Good morning and welcome to an oral argument session of the 5th District Court of Appeal. Let me begin by introducing the panel. As you've already heard, I'm Judge Palmer. To my right is Judge Sawaya. To my left is Judge Evander. We have one criminal and one civil case on the docket today, 15 minutes per side on the criminal case, 20 minutes per side on the civil case. Appellant can reserve as much of their time for rebuttal as they like. First case on the docket is Hernandez versus State.
Good morning, Your Honors. My name is Michael LaFay, and I represent EDWIN Hernandez here. May it please the Court and Counsel. And I will be reserving several moments for rebuttal. Thank you. Your Honors, in reviewing the briefs, there seems to be a good community of interest, a community of agreement between the parties. And that is, first, I believe both parties would agree that the lower court's ruling is flawed and wrong. And that is to say that when the court, reviewing a due process objective entrapment motion, decides that it should be denied based on the predisposition or what I'll call a slip of the tongue, the propensity of the defendant appellant, that is simply at odds with prevailing case law, that being as enunciated in Munoz, the Florida Supreme Court opinion that governs this area.
Would you agree that because the test for objective entrapment is a matter of law, that even if the trial judge made that mistake, we were reviewing it de novo and we have the same ability to decide whether the state's conduct was egregious enough to constitute a due process violation?
I do believe that is the issue before this court, and I think that's the sole issue.
And we're in as good a position to make that decision as the trial court?
Yes, Your Honor.
Okay.
Framing that issue just a little more, the state says, well, under their tipsy coachman argument, says, well, the governmental or law enforcement conduct here was not egregious enough.
Would you agree that's the test?
I do.
Okay.
I think under due process, I think that, and that's what it says in Munoz. It says, quote unquote, we look for, under due process, egregious police misconduct. And I think there's some commentary about that in the state's case that's been cited, Farley. I think that's a 4th district. And I would agree, given all the agreements that are going on, that it is a somewhat high bar for the appellant, but nonetheless, it is due process, it is flexible, it is not rigid, and it's not something that's easily pigeonholed. And I think that to flesh out what
is objective entrapment simply nomenclature, a label that can tend to be misleading? Is there really any such thing as objective entrapment, or is it just simply a due process standard that we apply? It
is a very muddy area, but I'm going to agree. I'm going to say that to the extent objective due process exists in this state, it is due process entrapment, and I think they're synonymous.
So you want to call it due process entrapment. Some people want to call it objective entrapment. It's just a matter of semantics as to what label you want to put on it. But really, we're talking about due process and whether the police conduct was egregious enough to violate due process. Isn't that basically what we're talking about?
That's correct, Your Honor. Right. And there are several cases. One I looked at, Dial, in 2001, well past the Munoz case.
Why is the police conduct in this case so egregious that it would violate due process?
There are, well, the first thing is that I think we need to look at is that the appellant here said no. And he said no 4 to 5 times. He said, no, I don't want to do it. It's too dangerous. No, I don't want to. Now, there's persistence by the confidential informant governmental agent here. And under the state's case law, they say, and it's true, in the face of a refusal, our cases say, look, for due process, police officers, confidential informants, you may persist. You can cajole. You can persuade.
Okay, so you've got the fact that he said no and that they cajoled him and persisted. What's your second?
The second thing is that the no, I'm going to say, is step one, and now when there is a no, we now enter at least into the area, the ballpark of due process. So then what can the police do? Do they cross the line? Do they step over it? And I'd say it's a Maginot line of some sort. But I think that, and our argument is that coupled with that no, the repeated no, when the police and their informants say, we will, what I'll call, give candy to the baby cases.
Right, before you get into the addiction issue, was it 4 or 5 no's over what period of time? A week or?
Several months.
Several months, okay. I believe the Casada case out of the 4th, but there were 20 to 30 no's, if you would, over a year and a half. And the 4th DCA said that's not sufficient. So would you agree that at least based on Casada, you have an uphill battle as far as the 4 or 5 no's?
I don't think the number of no's is important because, again, we look at police, the focus is clearly on the police and the confidential informants. So they cannot restrict or, if you will, expand due process by the amount of times they ask. If they just want to ask once and they get a no and then they go to the next level, which is, well, we'll threaten your family. Well, that's not 30 no's. On the other hand, if they want to ask 100 times, and apparently under Casada and the other cases, they may repeat and persist. And that's fine. That does not offend due process. And I'm going to say that's under the case law, and that's why I started saying, this is a high bar. But then when they redouble their efforts and they circle and outflank and come back to the target, preying on some weakness. Now, the cases say, well, what about when there's someone who's lonely and they offer a sexual relationship and an intimate relationship, romantic relationship? They say, no, you cannot do that. That's preying on a weakness. Going back to Justice Frankfurter's concurring opinion in Sherman, and I think that's the
You're basically saying that the defendant was a drug addict, and when they offered him drugs in exchange for for the deal, that was basically preying on a weakness that he had, which was his addiction. Is that basically what you're saying?
That's crystallizing the argument. Yes, Your Honor.
Mr. LaFay, let me ask you, there's some cases where the person is a recovering addict, and that is that they are no longer using or trying to avoid it, and the state, a confidential informant says, look, I'll give you drugs as part of the deal if you arrange this transaction. And I can see where that could be considered certainly offensive, that you have someone who's trying not to use the drugs, and here the state is trying to hook them back up, get their addiction going again. Are you aware of any cases where the defendant claiming the entrapment defense was admittedly still using drugs and had not indicated an intent to stop using the drugs at the time of the alleged entrapment?
The case is cited as Pizzella. And in Pizzella, is decided pre-Munoz and under objective entrapment. But there, the court says, and it may be dicta, but they say, this is just reprehensible conduct. When you offer an addict his drug of choice to convince the person to commit a crime. And in Pizzella, I might say that in Pizzella, Mr. Pizzella gave a qualified yes. He said they came to him, they said, hey, first he sold 10 Quaaludes. They said, okay, what about 1,000? He said, I will do it only if you let me have 100 and sell 900. That's a qualified yes. I'll do it under these conditions. That's not even a no. And they said, and in that case, the court said, it doesn't matter. This man's an addict. You come to him saying you will give him, under these circumstances, 100 Quaaludes for dealing 1,000. That is holding candy out to a baby. It's not something that we, as a society, should countenance.
So is it your position that in that case there is a bright line test? Whenever you offer drugs as part of the deal, it necessarily violates due process, or is this one of several factors and you look at all the circumstances?
I think it's a test. It's a case-by-case basis. That's what the concurring opinion in Sherman says. It says it is the duty of courts to pick and choose in this area, to cast its eye on government conduct and pick and choose and say, we will or this will not be accepted. And so I would say that, for example, there's so many drug addicts that are involved in drug trafficking. And if somebody says, hey, I'm going to do the deal and I need a piece for myself, fine. I mean, all kinds of people involved in drugs, and police have a job to do, and I know the court knows that and the state has argued it. But when there's a no, and when the government itself comes up with the idea of, look, we know you're an addict, and we will give you your temptation. We'll provide you with what you will do anything for. And at that point, then we get into where, indeed, the government has crossed the line of due process. I don't think that due process is rigid, and I don't think it's easily pigeonholed. And I do think that the courts, and my argument is that the court does have to pick and choose. But when there is a no,
we're talking about a record that contains the testimony of, I believe it was your client, and that was basically it. The state indicated to the trial judge that, well, we didn't have time to subpoena the confidential informant, we didn't have time to really prepare for the hearing, and the trial judge wanted to go on with the hearing anyway. Why wouldn't it be the appropriate thing to do to remand it back so that the state would have an opportunity to present all of their evidence to the trial judge as well?
Because this is...
And they didn't have a chance to do that, did they?
They certainly did.
They did?
They did. I may say that, the state waited 130 days to file this case. There were 40 days left in the trial period. Within the 30 days allotted to the defense, we deposed witnesses and filed our motions.
Didn't they move to continue the hearing, indicating that they didn't have the opportunity to subpoena the confidential informant, and they couldn't have their witnesses there, and they wanted to have the hearing continued? Did that happen or not?
It happened towards the end of the hearing. I believe that there was a conversation where the state said, we would like to, after...
Yes, you said that happened after most of the hearing had taken place, not before?
That's my memory, Your Honor, but I defer to the record.
Because I got the idea from their brief that that they really didn't have an opportunity to present all that they wanted to present at the hearing, that they'd asked for continuance, and the trial judge wanted to go ahead with it anyway.
I clearly remember after the testimony of the appellant that they did, and I'm not sure if they did prior to that, but we were right up against speedy trial due to the lengthy delays, and that was the problem.
Wasn't there some pending issue about whether they had to disclose who the confidential informant was, and the court hadn't ruled on that yet, and that's why they said they weren't in a position to have subpoenaed him?
They had not disclosed the confidential informant. The criminal rules do provide that without disclosure, the confidential informant cannot be used in a hearing or the trial. So disclosure is, in fact, a condition precedent.
So were they right when they said that they couldn't have the confidential informant there? They couldn't subpoena him to be there?
The motion had been filed on March the 15th. We're now 10 days down the line. I understand in the state's brief they said there was an intervening Easter or 3-day weekend. So,
Mr. LaFay, let me ask you, if instead of offering a portion of the cocaine, it had been an offer of money, if you get me, hook me up with some individual to sell this amount of cocaine, I'll give you $1,000 or $500 or whatever, what would happen to your argument?
I guess my response is this way, Your Honor. Because due process is elastic and flexible, if, for example, someone were to say, I'll get you the cocaine, give me $10 for cab fare. Man, I got to go get it. Well, they give them $10. Well, what about if they gave that same $10 to a starving man? They said, you want to eat? Here's $10.
Okay, well, under the facts of this case, if the money offered had been the street value of the cocaine that was part of the deal, what would happen to your argument?
The fact that drug dealers are in the business to make money, I don't think that offends due process at all. And I think that the police can offer money in excess of what it, depending on what it is. The cases say, well, is there exorbitant gain to the person? If so, if it's exorbitant gain. In one case, I think they offered to invest in a woman's business, and I have that case.
The reason I ask is because one of the questions raised in the state's brief is they say, what's the difference in this situation where the person's buying cocaine twice a week to offer cocaine rather than money?
And the fact that that the appellant is selling cocaine, purchasing in small amounts, his conduct is just not the focus of due process.
Right, but I'm just saying, what's the difference from a due process consideration if you give him cocaine rather than if you give him money when he's buying cocaine every other day anyway? He can just take the money and, in effect, turn it into cocaine by keeping his routine of buying cocaine every other day or so.
The only answer I can give there is that the courts in Pizzella, in every case where they have preyed on somebody's weakness, law enforcement has, and in this case it is a cocaine addiction, that has been held to be a violation of due process. Sherman and Pizzella and the other cases were sex and other things. Now, could somebody convert the money into cocaine? Sure. But in this case, the testimony was from Mr. Hernandez that he wasn't interested in the money. And he only did it after they had already offered him money, and he said no. And then they said, "Well, what about cocaine?"
Is there any evidence that he'd been involved in a drug deal this large, involving this amount of drugs?
Mr. Hernandez testified he'd never seen more than an 8-ball. That is to say, 3 grams of cocaine in his life. I would reserve my last 30 seconds for rebuttal. Thank you.
May it please the Court, my name is Chris Davenport, and I represent the state of Florida. First of all, as to what the appropriate test is, I think there is some confusion in the case law because they call it objective entrapment, which is what it was called under the Cruz test. And, defense counsel mixed up those concepts in his initial brief, and I think he mixed it up below, too. There's a difference between those tests. Cruz is a much lower standard. Cruz is a standard that was used in the Pizzella case that counsel cites so frequently.
Let me ask about Pizzella. I think your opposing counsel was candid saying it was dicta where they made that statement because the decision was based on the old Cruz test. But what about the statement in Pizzella that it's reprehensible conduct to entice a drug addict to participate in an illegal drug sale by promising him drugs for his personal use? What's your response to that dicta?
My response to that is, first of all, reprehensible conduct isn't the same thing as a due process violation. We're talking about conduct that's so outrageous the court system shouldn't even be involved in allowing the case to be prosecuted.
So
that's
it's
a pretty
okay
high standard.
if the police engage in reprehensible conduct? If that's all they do, that's not enough? Is that your position?
I'm saying it's not a due process violation to engage in reprehensible conduct. Personally, state's position is it's not that reprehensible to say, we'll cut out the middleman and you can just have a chunk of this cocaine so you don't have to go back to your supplier since that's what you're going to use the money for.
Is it as reprehensible as the factual situation in Pizzella? So is it your position that Pizzella wasn't reprehensible enough either?
I don't think Pizzella was reprehensible enough to find a due process violation, number one. Number two, in this case, you have a guy who's actively buying cocaine on a regular basis. I just don't see a big difference.
He'd never been involved in a deal that involved this amount of cocaine.
He testified he'd never done a deal that big, but he found a supplier pretty readily who could bring a kilo of cocaine to a deal. So it's not like
what about when you factor in the fact that, and I know we're going on a record where basically it was the defendant's testimony that we're going on. That kind of bothers me a little bit too. But in any event, what about the fact that we have a drug addict that's offered drugs if he participates in the deal, and couple that with the fact that he said no on several occasions to the police and didn't want to be involved until they kept coming back and coming back. And I know that the latter factor may not be enough, but when you couple the two together, why wouldn't that cross the threshold test as to whether it was egregious enough to be a due process violation?
because it's such a high threshold to be a due process violation, and this conduct just isn't shocking. You have to arrange an undercover buy like this, you have to call the guy. I mean, it's just something that has to be done.
But for the police to go out and get drug addicts that they know are addicted to drugs and entice them into an illegal drug deal with the allure of drugs if you do it. And they say, no, they didn't want to participate, but the police keep coming back and coming back. I mean, you don't think that that's egregious enough to warrant a due process violation?
Not when there are cases where they call them daily for months on end and they say that's not a due process violation. I mean, that's more pressure than what a couple phone calls over the course of several months. And, he says he's a drug addict. Again, there's not a huge difference between giving a drug addict $5,000 and giving a drug addict a couple ounces of cocaine. I mean, it's just a matter of, is he going to have to turn around and go?
Yeah, but there's a difference. There's a difference between money and drugs. You're offering the guy drugs, something that the person is addicted to, that the person craves, has to have.
Right.
I mean, people. There have been cases that we know where people have killed, have robbed, have committed horrendous crimes simply to feed their drug habit, and the police come to them and say, "We'll give you drugs if you participate in this deal." And he says no on several occasions, and finally convince him to do it.
Well, but there's cases where people will rob a convenience store to get money for drugs too. I mean, there's not a big jump between giving a drug addict money and giving him the cocaine directly. And let me cite this court's decision in Purvis, where there were frequent communications like in here, and they offered substances or money. This court said that didn't even violate the Cruz test. Now, granted, here we have testimony that the guy says he's addicted to drugs, but, there's not a huge jump between giving a guy a cut of the proceeds and giving him a cut of the...
Yeah, but he's not addicted to money. He can take the money and go buy whatever he wants to with it. He's addicted to the drugs, and that's what the police were offering him in exchange for the criminal activity.
True. They induced him to do this. I don't think there's any question about that. The question is whether that conduct was so egregious that the court system would find it shocking to even participate in this case. And it just doesn't meet that kind of high standard. When you look at cases where due process has been violated, it's stuff like the police going out and manufacturing crack cocaine and then selling it in front of a high school. I mean, that's pretty egregious compared to what we have here, where you have a guy who's routinely buying cocaine, who's selling marijuana on a routine basis. So he's not innocent.
He's never been involved in a deal where the amount of cocaine was this large before, and he said that to the police.
He did say that,
and that's why he
true.
said no, and they kept coming back.
But he was also pretty willing to take the next step as soon as the opportunity presented itself. And he was able to take that step. This isn't some innocent guy who just walked out of rehab and was trying to turn his life around. This is an active drug seller and an active drug user who found no big deal finding a dealer who could provide a kilo.
He's an addict, isn't he?
He said he is an addict,
yes. He
yes.
has to have the drugs, doesn't he?
Right. That's what he said.
And the
that was
police
his
go to him
testimony.
and say, do this crime for us, and we'll give you the drugs that you need and that you want and that you have to have. That
That's
you can't
true.
do without. All right.
They did do that, and no case has ever found that to be a due process violation.
Well, but when you couple it with the fact that he didn't want to do it in the first place, and he said no on several occasions, and the police kept coming back with the allure of, we'll give you these drugs and, go do the deal.
They did come back, but we're
you're
talking
saying
4 or 5 times over the course of several months.
Well, how many times does it take then? I mean, is there a rule where we say if it's this many times, it's a violation? If it's less than that, it's not a violation?
I think you have to find pressure so extensive you find it outrageous. And 4 or 5 phone calls over the course of several months isn't outrageous. I mean, when you consider that's what the standard is it outrageous for them to call over the course of several months? The guy's trying to arrange some buys. Is that outrageous? It doesn't seem to shock the judicial sense of justice. And that's what the test is, and I don't think it can be met here. No case has found it in a situation like that. It's always in cases where you look at what the police did and said, wow, that's ridiculous that they were allowed to do that. This is, a common thing. I mean, they arrange these buys all the time. That's how they get to the big guys, is by using the little guys. They can't get to...
Well, this isn't a big guy.
But they got to the big guy who provided the kilo by using this guy.
Well, but that may be... But now you're prosecuting the little guy because he's a drug addict, because he participated in a drug deal to feed his own habit.
Right, you're prosecuting the guy who had connections with someone who could provide a kilo of cocaine and was perfectly willing to use those connections.
We're not talking about the big guy that sold it to Hernandez. We're
Right.
talking about Hernandez,
But
right?
my point is to get, I mean, you know, to get this guy off the street, you're like, come on, what's the big deal? He's a pot dealer. But he also has connections to the bigger guy and was willing to use those connections to
Right,
take
you got the
next
big
step.
guy. You got the big guy, but that doesn't necessarily mean you have to prosecute this fellow
But we
based on.
can't, we got the big guy, but we can't just let this guy go. So it's our position that it wasn't outrageous.
If we find that it was entrapment, that's not going to affect the case against the dealer that sold it, Hernandez. is it?
True, but it'll affect police using these kind of undercover buys, and is that really
No,
a
it will
bad?
affect the prosecutor's decision whether they want to prosecute the little guy after they got the big guy.
Well, I don't think the little guy should be let go because he's a little guy. I mean, you know, he got, what,
Well,
3 years or 10
I
years,
know,
I guess.
I know, but we don't know what the issues were when the dealer that sold it, Hernandez, was prosecuted. Maybe
Right.
there wasn't an entrapment issue there. We
Right.
have an entrapment issue in this case.
We have an entrapment issue that
Or
doesn't
we
meet
have
the standard.
excuse me, we have a due process issue in this case.
We have a
right?
due process argument, but it
Argument.
doesn't meet the test.
All right.
And let me say, at worst, what should happen here is a remand so that the state can call its witnesses. They brought this up at the beginning
Why
of the
didn't you
hearing.
have your witnesses there?
They didn't have enough notice.
How much notice did you have?
10-day, well, it was like, I have the dates in my brief, but it was over a holiday weekend.
Was there a
stuff.
problem with the confidential informant not being disclosed, and that's
Yes.
what?
And that caused, you know, they couldn't bring him there until the court had ruled on the motion to disclose.
Yeah,
So
were
that's
you
why
allowed
they
to even
put
bring the
there.
witness until the court ruled on that motion?
The state didn't want to bring the witness until the court had ruled on that motion. So we would ask you to affirm, or at worst, remand so that the state's witnesses can be.
You agree that the trial got it wrong in its reasoning, correct?
I agree that.
There wasn't a
that-
subjective
Right, but
argument
there-
here, correct?
Well, what they argued below, and again, this goes back to the fact that courts are using these terms a little loosely, and it's causing some confusion. They argued the subjective entrapment under Cruz below, and then the prosecutor said, that's not the law anymore, the law has been changed to subjective entrapment, which is true. And so the prosecutor argued about that, and that's why, you know, it was all part of the arguments by counsel.
Well, isn't
The
it
court
real-
said, and he argued due process below as well, there's no question about that. And the court said, I find that there was no entrapment, and then he goes on and makes this propensity finding. So it's a little superfluous, but it was incorrect, yes.
Well, let me ask you about this idea of go back for a further hearing. This ended up being a plea case, right?
Yes.
After the motion to dismiss was decided, whatever arguments you had about it, it then turned into a plea case.
Right.
And the state agreed that this was dispositive,
Right.
correct?
Yes.
They didn't make an argument in connection with the plea that, yes, they'll be able to argue about this hearing and we'll be able to argue about whether we're entitled to more of a hearing, right? The argument was the motion to dismiss was dispositive.
Right.
I'm going to reserve the right to argue that the motion to dismiss should have been granted. You all didn't reserve some right to argue a right to remand and have a further hearing as a part of the plea, did you?
No, there was no mention of that, but, you know, we had won at that point. So I don't think the prosecutor was thinking, but what if it, you know, what about all these other aspects of it?
But
Question is-
your stipulation that the motion to dismiss is dispositive means if they're successful on the appeal, then they get a reversal?
It means if the motion to dismiss should have been granted, it would eliminate the case. That's what that stipulation means. It doesn't mean, you know, we agree with their argument or any part of it. If the motion to the court's ruling on the motion to dismiss is reversed, I would say you would remand it so that we can have all the real facts here instead of just the defendant's testimony. And then if he wins below, that would be dispositive. If we win below, it'd still be dispositive.
Well, is it
But we
your
don't have everything.
Is it your position that the defendant's testimony, which outlines his position on the case, isn't outrageous enough?
Yes.
And therefore it's irrelevant what you put on?
That's our position. That was the trial court's ruling, and we agree with that ruling. It's
Did you-
not outrageous taking everything he says is true. He's never seen a kilo before. He's an addict. The informant
So
knew
what
he was
would
an
be the
addict.
purpose of sending it back for a further evidentiary
If this court
hearing?
finds that that does demonstrate outrageous conduct, then we need to have the facts to see if that was true.
Did the state proffer what their testimony would be so we can evaluate whether it would have made a difference?
They did not because they won. The trial court found this is not a due process violation, taking everything he said is true. The state didn't need to go and say, well, we have all these facts too.
Well, did you ask the trial court to put on evidence, and you were denied the opportunity to put on evidence?
The prosecutor asked for a continuance, said we can't get our witnesses here. The court said, let's go forward with what we have. And then at the end they say, if this is good enough, then we need time to put on our case too. And the trial court said it's not good enough.
You know, even though it appears the trial judge applied the subjective test rather than the objective test, is it relevant in considering whether there's a due process violation or not, whether the defendant was predisposed to sell drugs? In other words, you know, like Sherman refers to a totally innocent person who's induced to commit a crime. Is it relevant in determining whether there's a due process violation that he was selling pot and buying cocaine? I mean, are those factors relevant?
Yes, it is relevant because you have to consider all the circumstances. I think it would be outrageous for the police to go and stand outside an NA meeting and find a guy and get his number and start calling him and offering him drugs. I think that would be outrageous. Here we have an active user who's dealing marijuana. I think those are part of the circumstances that you have to evaluate to consider whether or not the police conduct was shocking. It's much more shocking to go to an innocent person than to go to a guy who's already involved in the drug trade. So that is a factor that should be considered, and it's considered in the cases. When you look at the Madeira and those 4th DCA cases where the boss went to an underling and said, I know you have pain pills, I'll buy them from you. He said, you can have them, don't worry if you're in so much pain. She said, no, I need to buy them from you. I mean, that's outrageous. If that same person had gone to a guy on the street who deals in other things and said the same things, it wouldn't be. So I think you do have to consider who the target is. And we would ask this court to affirm. Thank you.
Thank you.
May it please the court, I think I have 28 seconds. Your Honor, Justice Evander, I'm looking at the Munoz case, and I quote from it, governmental misconduct which violates constitutional due process right of a defendant, italicized, regardless of that defendant's predisposition, requires dismissal.
You know, I understand that language. And then you have Sherman, which is, you know, refers to the attic situation and uses the language an otherwise innocent person. And so I'm trying to reconcile, you know, Sherman, the U.S. Supreme Court, using the otherwise innocent, and then you have the Florida Supreme Court using the predisposition issue. So, but go ahead.
Sherman is a subjective entrapment case in the majority of opinion. However, and they say a lot of due process things in it. It's a little bit muddy. However, Justice Frankfurter's concurring opinion is the forerunner of
and
due process.
they also refer to innocent and otherwise innocent.
They say no matter how low a human being has sunk, he is still entitled to due process protections from governmental misconduct.
How do you respond to the state's argument about the potential for remand here? That since they won, they didn't have to put anything on. If we find what evidence is in the record wasn't sufficient or was sufficient, why shouldn't they then have the right to put on their testimony?
What I heard the state say was, even if this court were to find de novo that the governmental conduct was outrageous and violative of due process, they should still do what with that? That is a violation of due process.
Well, I think the argument is they would present additional testimony so the court could determine based on all the facts whether or not it was outrageous.
For instance, they could say there were no calls, that your client's the one who went to the confidential informant and said, hey, I can get you this deal, are you interested? And we don't know what the state's evidence would be, which may be a separate issue. But.
And arguably it could be, I said no 5 times, and they could come in and say, no, he didn't say no 5 times. He only said no once, or maybe he didn't say no at all.
I can only echo what the court said, and that is this motion was dispositive. They had 9 days to put on their witnesses.
Yeah, I know,
find it disingenuous.
But they told the trial court that, look, we don't have the opportunity to have a full hearing. If you're going to rule one way, we'd like the opportunity to come back and rebut some of this testimony, put on our own testimony. If you rule the other way and we win, there's no need for us to do that. That makes sense, doesn't it? And so the trial judge ruled their way, so there was no need for them to present anything. But it was made clear that if they went the other way, they would like the opportunity to put on some evidence too. Isn't that right?
I would disagree, and my disagreement is founded on, it's disingenuous to say the reason why we can't call the confidential informant, Your Honor, is because we have not disclosed him.
Now, Ms. Davenport, I think, represented to us that they told the judge, look, Judge, if you're going to, rule in our favor, then that's fine. We don't need to put on anything. But if it looks as though you're going to rule in favor of the defense, we would like an opportunity to put on some evidence too. And the trial judge said, okay.
The record simply...
Is that what the record reflects or not?
The record reflects a comment by the prosecutor saying, Your Honor, we would like an opportunity to call our witnesses and we don't have them here. We didn't get sufficient notice. We only had 9 days notice. And I think the defense responded, where in the rules does it say that you get more than 9 days? And the court said, I'm just denying that. Denied that request.
Thank you, counsel.
Thank you.